Nobody wants to think about this, but ignoring it doesn't protect your family. It just means the government and the courts make the decisions instead of you. What happens to your money when you die in Canada is actually one of the most important financial topics you'll ever deal with. And the rules are different from what most people assume, especially around TFSAs, RRSPs, and what happens if you die without a will. Today, we're covering all of it, clearly, simply, and without the legal jargon. If you die without a will in Canada, you die intestate. That means the province decides how your assets are distributed, according to a formula, not your wishes. In Ontario, for example, if you're married with children, your spouse gets the first $350,000 of your estate plus a share of the rest. The remainder is split between your spouse and children according to a set formula. If you're not married but have a long-term partner, even one you've lived with for years, they may get nothing. Common law rules vary significantly by province. If you have young children and no will, a court will appoint a guardian for them. That guardian might not be who you would have chosen. A basic will in Canada costs between $300 and $1,000 through a lawyer, or less through an online service like Willful or Epilogue. For most people under 50 with modest assets, an online will is entirely adequate. This is genuinely one of the highest value financial tasks you can complete in an afternoon. Here's something most Canadians don't know. Your TFSA, RRSP, and life insurance do not automatically flow through your will. They pass directly to whoever is named as your beneficiary, regardless of what your will says. This is actually great news because it means these assets can transfer to your loved ones quickly, privately, and without going through probate, the court process that validates a will and can take months. But it only works if you've actually named a beneficiary. If you haven't, or if your named beneficiary has died and you never updated it, those accounts fall into your estate and go through probate after all. In Ontario, probate fees are 1.5% of the estate value over $50,000. On a $500,000 RRSP, that's $6,750 in fees that could have been avoided entirely. Log into your Wealthsimple, bank, or brokerage account right now and check who your beneficiaries are. If those fields are blank, fill them in today. If your life circumstances have changed, divorce, new children, a death in the family, update them. This takes 10 minutes and could save your family thousands of dollars and months of stress. The TFSA and RRSP have specific rules worth understanding. For the TFSA, if you name your spouse or common law partner as a successor holder, not just a beneficiary but specifically a successor holder, they inherit the entire account, including the contribution room, with no tax consequences whatsoever. The account simply becomes theirs. This is the most tax-efficient outcome and should be set up for every married or partnered Canadian. If you name anyone other than a spouse as beneficiary, a child, sibling, or parent, they receive the money, but any growth that occurred after your death may be taxable. Still much better than going through your estate, but not as clean as the successor holder arrangement. For the RRSP, things are more complicated. If you name your spouse as beneficiary, the RRSP transfers to their RRSP tax-free. If you name anyone else, the full value of the RRSP is added to your taxable income in the year of death, and taxed accordingly. A large RRSP with no spousal beneficiary can create a tax bill of hundreds of thousands of dollars for your estate, which ultimately reduces what your family inherits. This is why married Canadians should always name their spouse on both accounts, and why single Canadians with large RRSPs should work with a financial planner to understand the estate implications. Here's your action plan from today's video, and please actually do this because it matters. 1. Check your beneficiary designations on every account you own. TFSA, RRSP, workplace pension, life insurance. Update any that are outdated or blank. 2. If you're married or have children and don't have a will, make one. Willful and Epilogue are both solid Canadian online will services that cost under $200 for a basic will. A lawyer is better for complex situations. 3. If you have a spouse, make sure they're named as the successor holder on your TFSA, not just a beneficiary. These 3 things take one afternoon and could protect your family from months of legal headaches and thousands of dollars in unnecessary taxes and fees. Next week, we're getting into tax loss harvesting, a strategy that lets you use investment losses to reduce your tax bill completely legally. It sounds complicated, but it's actually straightforward, and it's one of the most underused tools in Canadian investing. Subscribe, and I'll see you there. See you then.